The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Says. Today we are talking about enduring powers of attorney. These are documents that I find people have often heard of, but don't have a great understanding of what they are and why they are. So that's the point of today. Enduring powers of attorney are documents that are governed by the Protection of Personal and Property Rights Act 1988. Now, in that piece of legislation, there's a section that is dedicated to enduring powers of attorney. These are documents that allow you to appoint someone to stand in your shoes as you if you have lost mental capacity. The purpose is that if you are unable to make your own decisions, someone is legally appointed to make those decisions on your behalf. The Act splits decisions into two categories: personal care and welfare and property. Now, let's deal with property first. Important to note at the top of this is that this does not relate to trust assets. So if you have a trust that you are a trustee of that holds your core assets, family home, business shares, investment portfolio, etc., those assets are not going to be dealt with by your attorney under an enduring power of attorney for property. The reason for that is that the enduring power of attorney for property relates to your personal assets. A trust holds assets. The trustees hold those assets on behalf of the beneficiaries. Therefore, the trustees don't hold those assets personally. They hold them for the beneficiaries, which means that it's not a personal asset of the trustee, and therefore the attorney cannot step into their shoes and administer that property because it is not their personal property. It's not the subject of that piece of legislation. So it's a very specific and very important policy reason as to why that does not apply. There are other mechanisms to be able to deal with trust assets in the situation where someone has lost capacity, but we won't go into those today. That's for another lesson. Today we're just focusing on the personal assets. So when it comes to property, you've got the option of appointing more than one person or multiple attorneys to be taking on that role if you lose capacity. You can also put different restrictions or provide different instructions to your attorney that they must follow if their appointment becomes active. This can be things like gifts that you would allow versus wouldn't allow, things like being able to execute a new will for you versus not being able to execute a new will for you. And it can also cover whether your appointment as attorney starts from the date of signing or only kicks in if the person loses capacity. So there's a number of different triggers, or different switches that we can pull in those documents. They are standard form documents that are required under the legislation. So we have a bit of room to play around, and what you'll find is that if you go to different law firms, you'll find slightly different versions, but the core of those documents is the same. They're horribly long documents because the legislation requires that we don't delete any of the options available to you. Now, the policy reason behind that is to make sure that you are aware of all the different options that you could choose, and then you proactively choose the ones that you want to apply to you. What that translates to is very messy documents that you need to read through with your trusted legal advisor. So when we're dealing with property, we're looking at personal property, assets that you hold personally. You can have multiple people appointed to look after them if you lose capacity. The second category is personal care and welfare. And this is decisions about what you want to happen in terms of care. If you're up at the hospital and you're unable to make your own decisions, then what is it that's going to happen? Both in terms of switches at walls and also in terms of surgical decisions, getting you out of the hospital system and into rest home care or other respite care, or just getting you home if you're unable to make those decisions. If you are in a coma or otherwise unconscious, then it also allows for more, let's call them day-to-day decisions of what needs to happen once you're in the hospital in terms of tests, etc., etc. The important thing about these documents, and particularly personal care, is that it allows for one person to have been appointed into that role so that then they have the authority to make decisions on your behalf. You don't have 10 family members all trying to claim that they knew you best and they knew what you would want in that situation as it is happening. You've got the person already appointed. The personal care and welfare, you only have one person appointed at any one time. You can have backups, but you can only have one person appointed. That's different to property. Property, I just said you could have multiple. Now, the reason for that difference is that when it comes to personal care, I believe that the policy reason is based on that you have to have someone that is making decisions, and it could be urgent, which means that you can't have a committee meeting between multiple attorneys. You've got to have someone in the hot seat that's able to make those calls to be able to crack on with making sure that you are cared for. As you then get out into care, there's less urgency around other decisions around long-term care, but the same principle can apply, that there needs to be decisions made, therefore it can't be that it drags on, that there's time lag while attorneys are trying to figure things out. In addition to being able to appoint someone as your attorney, in both sets of documents you can add that you want your attorney to consult with people or provide information to people. Now, the consulting means that people need to be proactively approached before a decision is made. Provide information means that people can ask the attorney for information if they so choose, but the attorney doesn't have to consult outwardly if it's just information that's being provided. So that's a critical difference of those two elements that can be added into both sets of documents. All right, now that we've gone through the two different types, property, personal care, let's flip back to first principles, which is that these documents only kick in if you have lost mental capacity. So what does that mean? There is legal definitions for what a lack of capacity means. And when it comes to enduring powers of attorney, effectively the legal test is, do you understand the decisions as they relate to your property? Are you able to look after your property yourself? Same for personal care. Do you understand the implications of your decisions when it comes to your personal health? Are you able to make decisions in respect of your personal care? These are relatively high thresholds, particularly for personal care, to make sure that if you are able to make decisions, that you continue to make your own decisions. It's not designed so that at the lowest or first possible opportunity that your attorneys can step in, because as a general principle, we want people to be making their own decisions. So although there is a legal definition, in reality what we have is the lawyers and anyone else involved really relying on medical advice around whether there is capacity or whether there is not capacity. So what's going to happen is that if there is someone in your life that is ailing, potentially losing capacity, the next port of call is to get a medical assessment done either by their attending physician, by their GP, or by a specialist to determine whether there is a lack of capacity. If there's capacity, then they carry on, usually with family support in order to assist them in the decision making. If there is not capacity, that's when the enduring powers of attorney are formally activated, and then the attorney steps in and starts making decisions. Now, critical to that discussion is that capacity is not necessarily a one-way ticket, or loss of capacity is not a one-way ticket. So if it is something like Alzheimer's or dementia, then generally what you'll see is some fluctuation, and then you will see that once it's past a certain point, there is no coming back in terms of legal capacity to make decisions. But when it comes to things like having a car accident and being in a coma, whilst you're in a coma, you lack capacity. You then wake up from the coma, you now regain capacity, which means that your attorney for a period was appointed, and then suddenly you woke up, you regained capacity. The attorney being active and making decisions for you ceases, and then you take control again of your own decisions. So the documents are designed so that they can come in and out of being active depending on the capacity of the donor, depending on your capacity as the person that has signed the document. And that's critical to that process. If you don't have these documents in place, and you lose capacity, the only way for someone to be legally appointed to make decisions on your behalf is through a court process. That process is going to take time. It's going to cost at least 5, maybe 10 times what it would have cost to just do the enduring powers of attorney at the outset. And in my opinion, most critically, it is not necessarily going to be an application by the person you would want to be making decisions on your behalf. So what do I mean by that? I mean, if you have 3 brothers and you would definitely want brother number 2 to be your attorney, but brother number 1 decides to make the application to the court and brother number 2 just really doesn't want to fight about it and allows brother number 1 to make that application to be appointed as your attorney, then suddenly you have the person that you didn't want making decisions for you legally entitled to make decisions. So not doing these documents means that you expose yourself to someone that you didn't want to be making decisions for you now making your decisions. There's a fair few people where that is unlikely to be the situation, where the immediate family that are likely to do the application to look after you are also going to be the same people that you would appoint in the documents. So I get that there will just definitely be a potential crossover, and the thing that I would reiterate is that you are not in control of it if you have not signed these documents. It is going to be up to the family and friends that have capacity around you to make decisions, to determine who is going to actually be appointed, who is going to have the support of the family and friends in making that application. Friends are going to be generally subservient to family. So if you have a closer relationship with core friends that you would want to be appointed, family might trump them when it comes to the actual court application. So these are all things to take into account when you're considering whether or not to get these documents in place. Now, the younger you are, the more likely that something running through your mind is going to be, well, I don't need to do this because it's mainly for people that have degenerative diseases and that's many moons away. I won't worry about it for now. Totally reasonable proposition. In the interim, you could have an accident. So that's going to be the big one that might catch you out. And the other thing is, I encourage my clients to treat it like insurance. Unlike insurance, this is a one-off payment, at least for a phase of your life. So what I see pretty regularly in people would be that they're in their 20s, 30s, maybe they have kids, maybe they don't have kids. They do enduring powers of attorney and they might appoint their parents, they might appoint their siblings at that point. Let's assume they appoint their parents. Those documents are probably going to last until that person is in a serious relationship, and then they might want to change it. They might want to change it so that they appoint their spouse or their partner rather than their parents. So those first documents might last 5-10 years. The next set of documents where they appoint their spouse, those will last generally until your children are old enough to take on those roles, if you have children. So then you would have a period of time, 15, 20 years, where those documents are perfectly fine. And then once your children are old enough to be the backups in behind your spouse, you would update them again, putting the kids in as the backup. If you don't have children, then your pathway could be from parents to siblings and then to nieces and nephews, depending on your age. So my point is that they're not documents that you'll put in the bottom drawer and never look at again if you sign them off when you're 30, but they are documents that you can expect to last for a season in your life. And then when that season comes to an end, you can then update the documents to reflect your new circumstances. Now, other than people being young and not seeing it as something that they need, even if they're not so young, some people see it as something they don't need. The other thing we come up against is the cost of doing it. As I've just gone through, it should be that these documents last a chapter in your life. It's effectively a one-off insurance payment to cover that phase of your life for the potential risk that you lose capacity. As you get older, the risk is higher that you're going to lose capacity. More important to have that insurance in place. Ultimately, hopefully, it's a waste of money. The dream is that enduring powers of attorney documents have been a waste of money, that they went into the bottom drawer, They lived out that chapter in your life. They got updated as they needed to be. You paid the cost, but that it was a waste of money because they never got used. No one takes out house insurance hoping for a fire. That is exactly the same principle that I encourage all of my clients to take when we're looking at enduring powers of attorney. No one hopes to lose capacity so that their enduring powers of attorney documents get used. The ideal situation is that we pull them out of a deeds packet, nice and dusty, once you've passed away, and I have a chuckle to myself about the conversation that we had 20 years earlier that they were going to be a waste of money, and then I put them aside because we never needed them. So today, Simon says, enduring powers of attorney are documents that allow someone to step into your shoes and make decisions on your behalf. Although you might not feel their effect on a day-to-day basis, having that insurance policy in the background means that if you ever need them, they're there. To support this channel, please hit the like button, subscribe, and if you've found this content interesting or you think that someone else might benefit from what we've talked about today, please share this with them. This is only valuable to those people that watch it. So, share around, enjoy, and remember, at LOA Law, we are good lawyers for good people.